Yesterday, I have mainly dealt with privatization in states. I've shown that privatization processes in states have decisively shaped new institutions and regimes of public international law, such as the human right to water and the international law of foreign investment. Inversely, public international law is shaping privatization processes. In the era of recurring financial and debt crisis to which international financial institutions and states reacted with privatization programs, the focus of attention has shifted from institutional concerns such as democracy and the state monopoly on the legitimate use of force to international human rights law. Notably, international social rights are increasingly viewed as giving rise to numerous procedural obligations of privatizing states, ranging from human rights impact assessments to granting participation and review. So, privatization modifies the substance and structure of state obligations under international law in two dimensions, shifting from state obligations to fulfill to state obligations to protect and ensure, and from substantive limits to procedures. Both shifts increase social risks. However, in pluralistic societies, the only way to identify the public interest seem proper procedures. Upholding a residual responsibility of the state vis-à-vis private actors furnishing public goods and services postulates that state public regulation and private regulation through the market offer two distinct, competing, and potentially complementary paths toward justice. That's my summary of yesterday. Today, I would like to deal with the privatization of and in international organizations, which is an important new trend. The key question is the following. Does outsourcing and privatization in the realm of international organizations raise different questions from outsourcing and privatization in the national realm? My answer is no, and the reasons will hopefully soon become apparent in the course of the lecture. I'm using the term privatization here in a somewhat broader sense than yesterday, including various uses of private law instruments by the organizations and the collaboration of the organizations with private actors, nowadays often called public-private partnerships. Again, this is of course not entirely new. Classic examples of engagement of international organizations with the private sector are the cooperation of states and telecommunications industry since the 19th century, and the tripartisme among labor unions, employers, mostly private employers, and governments within the International Labour Organization since 1922. Besides the official core mandate of international organizations such as the International Finance Corporation and the World Bank Group, and historically the first generation of commodities organizations on sugar, cacao, tin, and so on, crucially revolve around commercial transactions of those international organizations on the market. Also, some few international organizations have been created in the forms of private law. For example, the Bank for International Settlements is a stock corporation under Swiss law. Its members are not states but central banks. It has nevertheless been qualified as an international organization. Or the European Financial Stability Facility, EFSF, which was created in 2010, is incorporated in Luxembourg as a public limited liability company, Société Anonyme, under the law of Luxembourg. Its functions, namely to address the European sovereign debt crisis, is since 2012 being performed by the European Stability Mechanism, ESM, which is an intergovernmental organization. Of the large scale of privatization of public-private partnerships and also of self-organization according to the private law-oriented model of new public management in organizations is novel. And the reasons for the recent massive resort to those strategies are similar to the motives of large-scale privatization on the domestic level since the 1980s. The 2001 UN General Assembly resolution on outsourcing practices, which I also referenced on the handout, mentions 4 basic reasons for outsourcing. A, to acquire technical skills not readily available within the organization, including flexibility to meet quickly changing circumstances. B, to achieve cost savings. C, to provide a source more effectively, efficiently, or expeditiously, and D, to provide an activity or service not needed on a long-term basis. That's what the outsourcing practice document says. These four reasons seem to be exactly identical to reasons of outsourcing by states. So just like states, the organization expect that the involved private actor's self-interest, notably their profit interest, can be exploited in order to reach as a side effect objectives in the global public interest. Privatization in the sense of selling to the private sector has so far only occurred with the organizations of satellite telecommunication. The previously intergovernmental organizations, Intelsat, Eutelsat, and Inmarsat, were dissolved around the turn of the 21st century, and their activities are since then run by private business enterprises. This has been a logical consequence of the privatization of the tasks they perform within the member states themselves. I will briefly dwell on the example of Intelsat. This was the International Telecommunications Satellite Organization founded in 1971. It has been dissolved through a decision of the International Organization Assembly of the Parties and by a US-American domestic statute called the Orbit Act. And these legal acts created a private firm called Intelsat Limited. Intelsat Limited is a Delaware corporation and licensee of the United States Federal Communications Commission. It is fully subject to US law. The satellites were sold to this Delaware company in 2005. The main reasons for this full privatization was the desire to create a pro-competitive ownership structure. The prices for the services of the previous intergovernmental telecommunication organization had not been deemed flexible enough, the governance procedures were deemed too slow, the commercial decisions too conservative, and the organization had no access to public equity markets. So we see exactly the same reasons as the reasons prompting states to engage in privatization. And the privatization of Intelsat also created similar risks. The question was asked whether the global public interest would be still served by the privatized satellite company. In order to ensure this, besides the new Delaware company, a small residual international organization was created in 2000. And this residual organization carries the old name, International Telecommunications Satellite Organization, but with a new abbreviation. The abbreviation is now ITSO. And ITSO now has the residual responsibility for telecommunication, but no longer the obligation to deliver. It also lacks the technical facilities to deliver the service itself. It only ensures the telecommunication. It acts as a guarantor of global connectivity on a non-discriminatory basis. This setup exactly mirrors the privatization of infrastructure in states. The public actor is relegated to a guarantor role. Its public tasks are modified from fulfilling or providing the public good to merely ensuring or guaranteeing it. The main point of such a public guarantee is, as with all infrastructure privatizations, the need to uphold the service also for poor clients, even where this would be under pure market conditions not profitable. In the telecommunications sector, we call this the LCO, the Lifeline Connectivity Obligation. The ITSO does guarantee this lifeline connectivity also for poor countries, if need be, through reduced rates and cross-subsidies. So what in domestic infrastructure are poor human clients, we here have the poor state clients. Apparently, the private entity's financial viability is not threatened by this scheme. Interestingly, however, the ITSO Public Services Agreement and the model contract with the terms and conditions of the Lifeline Connectivity Obligation do not seem to be publicly accessible. At least I didn't manage to access them. So this privatization of international telecommunication does not fully satisfy the demand for transparency, which I had formulated yesterday. In comparison to the privatization of domestic infrastructure in states, we have one additional problem, namely that Intelsat Limited, the Delaware company, is under the laws of the United States. Some feared that therefore the private company would be bound to comply with US economic sanctions, for example, sanctions against Iran. This would, of course, have rendered a global service impossible, but apparently the company is not bound to the normal US obligations for national firms. I now turn to the increasing, although hardly legally definable, phenomenon of private sector partnerships between international organizations and private, that is, business actors. As you know, public-private partnership is not a legal term. PPPs can come in totally different legal forms and intensity. They sometimes amount to the actual establishment of hybrid public-private bodies, such as the Global Water Partnership or the World Anti-Doping Agency. I will in the following concentrate on United Nations partnerships. In its Millennium Declaration of 2000, the UN General Assembly decided, I quote, to give greater opportunities to the private sector, non-governmental organizations and civil society in general, to contribute to the realization of the organization's programs. End of quote. Since then, partnerships have been burgeoning, notably in the fields of environmental action, especially climate, humanitarian action, conflict and disaster response, and also refugee management. The most institutionalized public-private partnerships exist in the field of global health. The WHO entertains very intense ties with the pharmaceutical industry. The most significant partnerships in this field are, for example, the Rollback Malaria Partnership, the Stop TB Partnership, or the Gavi Alliance, Global Funding Alliance for Vaccines and Immunization. These health partnerships raise serious problems of conflict of interest when it comes to influencing health policies, the vaccination and medication strategies and recommendations of the WHO. Recently, the United Nations launched a business UN action hub. The title of the webpage is, I quote, "Where the UN and business connect and partner to advance the Sustainable Development Goals." The webpage says that this Business Action Hub was developed as a joint effort of the UN Global Compact and of a Hong Kong-based non-profit specializing in facilitating private sector and NGO connections, and 20 further UN entities. What are the objectives and the substance of these PPPs? The partnerships can relate to advocacy of global issues. They can relate to project funding, to the provision of goods, or to the provision of services and personnel, or to standards and guidelines for development. The main area of PPPs is sustainable development. Realistically, the United Nations acknowledges that in most states of the world, the actual economic activity, the production of goods and the delivery of services, is performed by private enterprises. And it's therefore logical to engage the private sector in the development strategy. But what is then its relationship to the states? Here the Secretary General, in a 2015 report, which I also mentioned on the handout, says that public-private partnerships are additional and complementary to government action and can yield positive results which governments may leverage to advance society's best interests. This statement of 2015 classically reflects the position of embedded liberalism, namely that the private, selfish, possibly profit-oriented action will unwittingly contribute to public welfare if this action is appropriately framed by the public actors and by the rules they set. This strategy can be illustrated with one example from a different industry sector, which I take from the most recent Secretary General report on public-private partnerships. In 2015, apparently the mobile industry launched the Humanitarian Connectivity Charter in collaboration with the World Food Programme and the International Federation of Red Cross and Red Crescent Societies. So here we see the typical triangle: private actor, then the public actor in shape of the World Food Programme, and a civil society organization, namely the Red Cross. Under this connectivity charter, mobile operators pledge to establish disaster preparedness plans and make mobile services more accessible in crisis by providing free or subsidized access to text messaging, data, and voice services to affected people and humanitarian and government actors. That's the description in the Secretary General report. Of course, we can assume that the mobile operators have their business case for this action. But is that a problem when it also serves the humanitarian objectives? I'll deal with the legal risks and drawbacks of the various forms of engagement with the private sector at the end of this lecture. Before, I will turn to one other area, seemingly less political, more technical, and in legal terms also clearer defined, namely the area of public procurement by international organizations. Of course, international organizations have always been procuring goods and services. And procurement is normally not discussed under the heading of privatization in a narrow sense. Still, I would like to mention it because it is a form of engagement with the private sector, and it has also enormously increased in the last decades. And it is, compared to its importance, both under-regulated and understudied. The value of purchase by the United Nations goods and services, according to the figures given by the UN Statistical Report on Procurement, has multiplied itself by the factor 300 in the last 15 years, between 2000 and 2015. In 2015, the total procurement of goods and services by the entire UN was in value of $18 billion, and half of it was in services, half in goods. The top procurer within the UN system is the UN Children's Fund, UNICEF. And the top product purchased are pharmaceuticals, including contraceptions and vaccines. And the top service for which the UN spends its money is mail service. The top country supplying the UN system was the United States, but only with 9.3%. So the origin countries of the goods and services are highly diverse. The procurement programs obviously pay attention to maintaining this diversity. And the statistics, which you can see, are specifically designed to show this diversity. For example, procurement from firms from economies in transition, such as India, are listed separately. We can distinguish three types of procurement. First, the procurement directly by the organizations, both for internal purposes such as office supplies or canteens or housing for staff. And second, we see the procurement of products linked to the function of the organization. Functional procurement, as a part of the organization fulfilling its mission, happens notably in the humanitarian sector. So the FAO buys food and seeds for distribution, the UNHCR buys tents for providing them to refugees, the WHO buys contraceptives, and so on. Another type of procurement which I will leave out here is the procurement by states for projects financed by an international organization. In this case, the state must observe the procurement rules of the organization. For example, the World Bank, Asian Development Bank, African Development Bank, and so on. The procurement by the organizations is regulated by internal rules, mostly procurement handbooks and guidelines. The most detailed manual is the general one for the United Nations, and I referenced the UN Procurement Manual also on the handout. As a general matter, one could say that the objectives of public procurement rules are designed for reconciling two conflicting objectives. On the one hand, obtaining best value for money, but on the other hand, also not to waste too much energy or time on market investigations, for which a public entity is especially ill-equipped. Further objectives of procurements are to safeguard the cleanliness of the administration by avoiding nepotism and favoritism. To that end, the manuals contain rules on transparency and impartiality. A side objectives of modern procurement rules is that social and environmental objectives are also allowed. For example, domestic procurement rules often allow or even prescribe affirmative action in favor of small and medium enterprises, or in favor of women-led enterprises, or in favor of green business, and so on. And the international procurement rules seek to guarantee some preferential treatment of firms from developing countries. The interesting finding now of Elisabetta Molino, a scholar whom I also referenced on the handout, is that in the procurement rulebooks and in the procurement practice of the organizations, the objectives of economy and efficiency of the administrative activity of the organization far prevails over the duty to take into account the positions and demands of those willing to contract with the administration. For example, the organizations rely on wide exceptions from the obligation to place an advertisement. In result, the bidders and contractors of organizations are not well protected against discrimination. The lax rules for the international organizations themselves stand in a stark contrast to the rules the WTO imposes on the member states in the WTO General Procurement Agreement. In that agreement, in the GPA, publicity and transparency are stretched to the greatest extent possible. So if we compare the accountability of states for flaws in their procurement procedures with the accountability of the organizations, we find that the accountability of the organizations is indeed much weaker. For example, under the procurement agreement imposed on states, the contractors themselves can challenge procurement flaws and can enforce the rules against the states. Much less review is available against the organizations. There are only some internal mechanisms, such as the representations before the issuing authority or ombudspersons, but overall the system is weak. This state of affairs is familiar from all areas of international organizations law. International organizations tend to impose strict rules on member states, but not on themselves. The area of procurement is a further but little-known manifestation of an accountability weakness in the activity of international organizations. A particularly problematic type of procurement is the procurement of security. Private military and security contractors, so-called PMCSSCs, have attracted a lot of public and scholarly attention, especially since the excessive reliance on contractors by the United States in the Iraq War of 2003. Everyone was shocked to learn first about torture and abuse in the infamous Abu Ghraib prison in Iraq, and second, that not only the US American Army, but also even mainly employees of private firms such as Agility Corporation, formerly called L3 Services, and Titan Corporation, and the so-called Consolidated Analysis Center Incorporated were in charge of running the prison. This area of privatization is particularly sensitive because it relates to a primordial public good, namely peace, to a core attribute of the state, namely its army, and to the most traditional public function of the state, which is to guarantee physical security. In contrast to the PMSCs hired by states, the employment of these firms by international organizations was until recently little known. It has been regulated and discussed on a UN level only since 2012. The main users are the World Food Programme, the UNDP, and the UN High Commissioner for Refugees. Of course, the fact that no international organization has any own military distinguishes the organizations from states. This basic fact has given rise to an indirect privatization of UN missions. Peace missions under Chapter 6 involve the use of such force, at least in self-defense, and as you know, the missions are sometimes also combined with joint state action authorized under Chapter 7. And for both constellations, the troops and police forces will always inevitably be furnished by the contributing states, and the states also reserve themselves the overall control and disciplinary authority over the soldiers and police. The point is now that some member states have to a large extent themselves privatized the police and the military. These member states then donate or offer personnel which they themselves have contracted. For example, the United States until 2004 exclusively sent police forces who were the employees of the firm DynCorp. Due to the complex and integrated character of many field missions, direct and indirect privatization of the mission may be combined. I will in the following now concentrate on the direct privatization of civilian humanitarian, peacekeeping, and integrated missions when the organization directly hires security personnel itself. The missions need guards, and they need protection for their personnel, for their premises, and guarding the equipment, performing whatever tasks, for example, running a refugee camp. Under a 1993 Convention on the Safety of the United Nations and a protocol, the security for all these activities should normally be guaranteed by the host state with its own means. But the host states are often not capable to provide the security needed, and therefore the UN has started to directly contract military and security firms. Among the peacekeeping and political missions of the past decade, the UN assistance mission in Afghanistan, UNAMA, was probably the most important user of private security services. But not only security in a narrow sense. For example, ahead of the Afghan elections in 2002 and 2004, the firm called Global Risk Strategies played a considerable role in assessing potential voter registration locations for the Joint Electoral Management Body Secretariat. According to the UN Procurement Division website, the Afghanistan mission spent more than $10 million on security contracts in 2012. Or, to give another example, a firm named Global Strategy Group reportedly supplied a range of security services to the UN assistance mission for Iraq. Or a firm called Pacific Architects and Engineers was responsible for running 6 airports in the Democratic Republic of Congo as a part of the UN mission MONUC, a service that included evacuating UN personnel when the UN came under riot attack. Importantly, subcontracting is going on here too. For example, when the World Food Programme outsources food transportation, then the food transport firm contractor might hire armed guards to protect the food convoy. The procurement of such armed security by the United Nations has come under political critique. First, there are problems of quality of the services, of the screening of the personnel, and so on. There also have been instances of the uses of disrespectable companies, and that's increased by the fact that the practices have been kept quite secret. It has also been said that the contracting practice goes hand in hand with an over-securitization of the missions, and commercial interests of contractors might lead to inflate risk assessments. The logic of the market favors short-term solutions as opposed to a long-term security approach. Taken together, these factors might lead to an erosion of confidence of the population in the United Nations. Awareness of these problems and also some scandals have incited regulation, and currently there are 3 sets of specific rules which govern the activity of PMSCs. But no hard international law exists. The debate about a binding convention on mercenaries is ongoing in the UN Working Group, which has been prolongated, but major Western states, not only the US and the UK, which are the main home states of the security firms, but also other states such as Switzerland and Germany, are opposing a binding convention. But as you know, there is one non-binding document, the Montreux document of 2008, which meanwhile has 54 supporting states, plus also supporting organizations, NATO, the EU and the OSCE. And the UN has internally specifically regulated the procurement of armed security. I mentioned the texts of the UN on the handout. There are guidelines and a model contract, and there is a policy manual which contains a chapter on armed private security companies. And the governing principles are, first of all, that the United Nations may hire armed private security companies only as an option of last resort. That's the main principle. Only when neither host states nor member states or any other internal United Nations system resource can provide adequate and appropriate armed security, then outsourcing is allowed. There is also, as a third set of instruments, a code, an international code of conduct for private security providers, adopted by around 50 military and security companies, And now participation has risen sharply up to 700 companies in 2013. That's the last figure which is on the website, when an association, a kind of rifle association, I could say, a rifle association was launched. And this association is tasked with implementing and overseeing this code. It's also called the International Code of Conduct Association. And the creation and now the operation of this association is a typical multi-stakeholder exercise along the three stakeholder pillars: the military and security industry, civil society, and governments. And these three stakeholder pillars are also represented in the governing bodies of this association. And interestingly, and very recently, the Code of Conduct also foresees grievance procedures, which were realized in 2016. And there is one procedure which allows third parties and also personnel of the security companies to report allegations of improper or illegal conduct, including violations of the code itself, to the Secretariat of the Association. The main paths then are company internal remedies, plus possible mediation and good offices by the association. If a member company fails to take reasonable corrective action, the Board of Association may suspend or terminate the company's membership. So far, I wasn't able to research any practice because it's totally new. The major legal questions surrounding private security companies have been well rehearsed in the intense debate on private security contractors hired by states. For example, the question of their status under international humanitarian law, the question of when the use of deadly force is admissible, and the detaining powers of the employees, and so on. Now, my question is whether there are any specific problems raised by the use of private security in UN peace missions. It has been said that the privatization of UN peace missions creates a disruption of the principles of the UN Charter because UN member states give away their responsibility for the maintenance of peace and security in the interest of the common good. However, I do not see here a valid legal reason for the UN which could justify it to refuse troops by member states which are in reality private contractors, for example, DynCorp employees sent by the United States, if the UN would wish at all to refuse them, which is anyway totally unlikely. Let me now take a step back and examine the problems of international organizations, privatization, including procurement of all kinds, from a broader perspective. So we have seen that international organizations seem to undertake privatizations as already known from states and for similar reasons. And also the various types of privatization engender political and legal risks, which also seem to be similar to the ones faced by states, while some problems may be specific. Specific policy problems are, for example, the risk of fragmentation of the UN system through the use of a great diversity of contractors and the risk of sapping the international organization's image as a universal, neutral, and impartial organization. The key question now is whether the legal problems, besides the political problems, are also identical or different between states and international organizations. Does the international context of privatization radically transform the underlying issues? Is the poorness of the rules, principles, and procedures which govern procurement and privatization in international organizations a real lacuna? Or can we live without sophisticated safeguards because the privatization of the organizations and their procurement poses significantly less risks than the parallel phenomena in states? A key difference is that a dyadic state versus society relationship does not exist on the international plane. And this means, importantly, that the political decision to privatize an organization or to engage strongly with the private sector is not taken in a directly democratic fashion within the organization itself. these decisions can at best be viewed as indirectly justified through the member states. But which normative consequences should we draw from this acknowledgement of a democratic weakness for the assessment of the privatization of organizations? I can't answer this question at the moment, but would like to draw your attention to one point, namely, also a seemingly technical legal question, is which law governs actually the procurement and all these kinds of partnerships when they are legalized? Generally speaking, legal instruments between organizations and private partners or contractors seem to be governed by private law. Private law as determined by the choice of law rules which are applicable to the constellation. One might ask whether a transnationalization or internationalization of such contracts is desirable, in parallel to the case of so-called state contracts. Transnationalization means to qualify the contract as being outside the domestic law of the governmental partner to the contract. The normative argument for such a shielding from domestic law is to meet the danger that the state party will manipulate its legal order to the detriment of the private partner. It is generally assumed that such a shield, effectuated through the requalification of the contract, is not needed for contracts concluded with organizations. But maybe the underlying assumption that, unlike states, international organizations do not have an own legal order which could be manipulated to the detriment of the contractor might deserve a re-examination. The second set of questions relates to the providers' and contractors' general legal obligations. Are they, under some conditions, directly bound by international law, notably by human rights law and IHL? Such obligations can only with difficulty and in specific constellations arise independently from the contracts, because the pertinent rules of international law are in principle not addressed to the private actors, and I will come back to this in the third lecture. However, international legal obligations of contractors might arise out of explicit or implicit referrals in the contractual clauses. The general conditions attached to the service and goods contracts impose core international law-inspired prohibitions on the contractors, namely bans on child labor, on involvement in the anti-personnel mine business, and a zero tolerance for sexual abuse. The question arises which legal nature and force such general conditions in the contracts have, and whether they are in conformity with general principles of international law. The possibility of qualifying the contracts as internationalized might speak in favor of reading into those contracts also an implicit obligation of the private side to respect the rules of international law. But I think that such an interpretation is acceptable only when it is covered by the contractor's legitimate expectations and by its presumable consent. With regard to privatization in states, it is usually warned that states must be prevented from escaping into the private realm and into the forms of private law, and thereby to shed themselves of the specific accountability mechanisms of public, including public international law. This evocation of the danger of a flight into private law is criticized by some observers as being exaggerated. The critique points out that private law too offers constraints and limits, which may in some regards even be stricter than those of public law. That's true, but it remains the case that the major public law constraints are human rights, and these do not directly and uncontroversially apply in the private law realm. So they risk to be circumvented by the so-called flight into private law. Is such an evasion, such a flight into private law, a concern for the organizations as well? Importantly, the evasion of an organization from public into private law is at the same time also a move out of international law into domestic law, into that domestic law which governs the contract. The question is whether that's a problem or a risk, and that depends, of course, on the comparability of the situation. I think that on the one hand, the situation of the privatizing state and of the privatizing organizations seem to differ in relevant respects, because the organizations don't perform a full-fledged service public. They are not the normal providers of public goods, ranging from infrastructure to healthcare. They are rather engaged in extraordinary services. And they have, of course, an extremely limited own staff and budget to perform their task. But although extraordinary, the service is performed by organizations on a widespread geographical scale. And it seems no coincidence that those organizations dealing with masses of persons in the field of refugees and health are the ones which are most intensely engaging with the private sector. Also, international organizations don't have an own territory, and they can therefore never host any investors. But the question is whether all these fundamental differences between the organizations and states remove all the risks of evasion into private law. I submit that that's not the case, that the risk of evasion is comparable. Because, however limited and based on delegation by states the activity of the organizations is, their raison d'être is to perform public functions, functions which the states are unable to fulfill well on their own when they act in isolation. And there may therefore even be some hardcore public functions in international organizations whose outsourcing should be absolutely prohibited. For example, negotiating the release of hostages. And this brings us to the elephant in the room, namely the human rights obligations, which are potentially affected by privatization. First of all, the extent to which the organizations are themselves bound by human rights law as a part and parcel of general international law, which forms part of the environment of the organizations, is still somewhat uncertain. The currently unresolved question is the delimitation of the organization's sphere of human rights responsibility in the first place, because the organizations lack a territory and a jurisdiction as states have. The sphere of activity of organizations has a potentially global reach, and this can potentially affect anyone's human rights. But we need, in order to demarcate the scope of obligations on the level of primary law, we need a threshold concept which would perform the threshold function which the concept of jurisdiction performs for states. And that is a prior and distinct question from the issue of attribution, although unfortunately the criterion employed to affirm both jurisdiction and attribution, namely control, has been conflated in the case law, as you know. It has been argued that not only states but also international organizations' social human rights obligations are defined by the academic Maastricht principles on extraterritorial obligations of states in the area of economic, social, and cultural rights. And that would mean, if we apply these Maastricht principles, that, for example, the Asian Development Bank would have to protect the right to social security of the Pakistani population in situations over which the bank's action brings about foreseeable effects on the enjoyment of social security in Pakistan. That's what the Maastricht principles would say on that. And also, the newly revised UN guidelines on cooperation between the United Nations and the business sector, they also ensure full alignment with the Ruggie principles. But it's an open question whether the Ruggie principles apply to international organizations at all. Are the organizations really legally obliged to protect victims against human rights encroachment emanating from contractors? And if the Ruggie principles apply mutatis mutandis, then would the organizations also be obliged to provide for effective remedies? The Security General Report on private partnerships of organizations promises appropriate grievance resolution procedures. But we know that this is exactly the shortcoming in the realm of international organizations for the time being. The currently most discussed constellation are the human rights obligations of the international financial institutions nudging states into privatization. The story of Greece, Cyprus, and Portugal in the debt crisis, which I recounted yesterday. Arguably, the state's privatization programs must observe social rights. The legal presumption against the admissibility of retrogression triggers an obligation to justify retrogression strictly and cogently. When social retrogression is de facto imposed by the IMF or by the ESM, do these or similar social human rights obligations also apply to the organizations themselves? I would argue that the main responsibility will lie with the privatizing state, for example with Greece, who has some leeway how and where to perform the social cuts. But one could at this point also extrapolate the European Court of Human Rights case law and Security Council decisions obliging states to impose targeted sanctions. As in the sanctions constellation, we might identify a legal presumption that the international institution will not ask a state to adopt unlawful measures, and that the organization's legal act can and must be interpreted in that sense. This presumption is all the more plausible as the prescriptions by the financial institutions are not binding, unlike the Security Council resolutions. Concomitantly, we can argue that the international body is indeed obliged not to frustrate the attempts of states to honor their social human rights commitments. So this would be a specific obligation to protect of the organization vis-à-vis states, which are the direct menacers. Notably, robust anti-discrimination rules seem as least as pressing for international organizations as for states. And this has to do with one further specific feature of organizations, which is their international character. Banal as it might sound, the international character of the United Nations has been most highlighted, more than anything else, in the UN rules on outsourcing. When outsourcing, the United Nations must respect the international character of the organization. That's what the rules say. And this demands that outsourcing must seek to serve all member states, or rather their firms, equally, so that procurement must happen on as wide a geographical basis as possible. If we assume that in principle organizations are obliged to respect human rights, then this brings us to the question of attribution. The question of attribution of private harmful action is of course an old question, but it appears in a new light in the era of privatization. And particularly, this is relevant in the field of private security, where serious breaches of IHL or human rights are at stake. The rules of attribution for the purpose of international responsibility of organizations are similar but not identical for a hiring organization as they would be for a hiring state. The effective control criterion is more controversial for the organizations and arguably doesn't really fit the complex constellation of UN peace missions. Another entry point might be to qualify the contractors, at least in some circumstances, as agents of the organization. Agent is defined in the draft articles on the responsibility of international organizations as, I quote, a person or entity other than an organ who is charged by the organization with carrying out or helping to carry out one of its functions. A provider of food for the High Commissioner for Refugees does help to carry out one of the High Commissioner's functions. So if the provider distributes contaminated food, which leads to a poisoning of the recipients and deaths, could the UNHCR completely absolve itself? And what about the subcontractor which protects the food convoy with arms? What if an employee kills a youth who tries to raid the food truck? The published general conditions of UN contracts seek to rule out any attribution to the UN. The conditions explicitly state that the contractors are not the agents of the UN. The question arises whether such a rejection of attribution and a rejection of responsibility by the UN can override customary law. But then the question is, does customary law on attribution to organizations exist at all? Especially the concept of agent is wholly vague, and its use in the draft articles has been criticized. Also, doesn't the contractor, through the contract, assume own responsibility, also under international law? But this then again depends on whether the contract, which incorporates the general conditions, is at all an instrument of international law, which could be considered overriding lex specialis to potentially countervailing customary law. I think that such a legal result would probably fail victims who are left alone with claims against the private contractors, although they would need a public guarantee by the UN. This brings us to the litigation options for contractors and for bystanders. Unlike in domestic privatization, legal disputes over contracts or over torts inevitably will raise the question of the immunity of the organization before state courts. As you know, traditionally the immunity of the organizations has been deemed absolute. And this stands in contrast to state immunity, which has since the beginning of the 20th century, in the court practice of most states, been reduced or limited to acta jure imperii. The main argument for insistence on the absolute immunity of international organizations has been that the organizations anyway are only allowed to act within the confines of their constitutional functions, and this limits their sphere of activity from the outset on. But the question is here whether this immunity must, in times of privatization, also be limited to acta jure imperii and exclude immunity for lawsuits arising out of commercial acts by the organization. This has been rarely accepted in the case law so far. I think that it is worth reconsidering, and that the general conditions of contracts, which the UN, for example, publishes and which I mentioned, they must be looked at more carefully. They refer to the arbitration under UNCITRAL rules, and they say that the decisions of the tribunal will be based on general principles of international commercial law. So here we seem to have an alternative remedy available, which would clearly satisfy the Wade and Kennedy requirements for upholding immunity as an admissible limitation of the contractor's right of access to a domestic court. But the situation looks different for innocent outsiders affected by the activity of contractors and providers. Let's assume that a commercial bodyguard engaged in the MINUSMA stabilization mission in Mali commits a rape, and that it turns out that in his prior life he had already been convicted to a criminal sentence, had escaped prison but was not screened properly before he was hired. On that basis, we might find a breach of due diligence obligations of protection on the side of the United Nations. Could the United Nations claim immunity for this? And is the situation different from Haiti? Does it make a difference whether harms stem from a contractor or from a real troop furnished by a member state, as in the Haiti cholera case? I leave this question unanswered for now and come to my conclusions for today. All aspects considered, the prevalence of similarities between international organizations and states seem to create a comparable risk of evasion into private law, both for states and for international organizations. Accountability may even be more diluted than by domestic privatization due to the double evasion. The double evasion of member states into international organizations and from there into the forms of private law. We have seen that in the realm of international organizations, legal devices governing privatizations are far less developed than in well-governed states. And this leads to the quest of refining the rules to govern the various privatization phenomena. In the area of PPPs and procurement, notably armed security procurement, it is desirable that privatizing international organizations create and refine the devices and strategies for screening the providers, for due diligence procedures, for proper reporting, for callback mechanisms, and some form of review and remedy. What is the ultimate objective of such strategies and mechanisms? The ultimate objective is to safeguard that the engagement of private contractors and providers hired by international organizations does not undermine the equal enjoyment of human rights of recipients and of bystanders. Obviously, recipients do not have any legal entitlement to services provided by international organizations. They are not entitled to receive food aid by FAO, to receive a house in a refugee camp furnished by the High Commission on Refugees. They're not entitled to obtain election supervision from the OSCE. They're not entitled to getting access to a telecommunication satellite. However, if an organization takes on the job, recipients are entitled to a non-discriminatory service, and they are entitled to some form of remedy should accidents happen. Despite all controversy in detail and despite all backlash, it is in the international legal discourse acknowledged that human rights protection, including equal protection, are among the most fundamental principles of international law. One might say, using the vocabulary of global constitutionalism, that these principles form part of the body of international constitutional law within international law. And the constitutional vocabulary might have the merit of signaling a body of principles which span the public and the private realm. Safeguarding constitutional values does not require to subject the private contractors to the identical legal regime as the public actors, but only demands that basic ideas are respected. And this will be mainly done by interpreting the specific legal instruments, for example the contracts, in the light of human rights, and formulating suitable general conditions to the contracts. So, and this is my conclusion for today, the so-called constitutionalization in international law can also be seen as a way to capture legally the ongoing privatization in international law, without, however, giving up the public-private distinction as a regulatory idea. Thank you.